Well, here we are, as promised, Sunday morning, bright and early, here to catch you up on everything that I was not able to catch you up on because of the Jewish holiday last week. But don't worry, we're going to catch you up on everything. Day 23, day 24, and especially day 25, which was probably the strongest day for the Commonwealth so far. We're going to jump into everything in just 1 minute, but first, if you haven't yet, please subscribe, like, join the Brother Counsel Sidebar membership, where it's an easy way to support the channel, and you'll get some extra content for a very affordable price. All right, now let's move on to the cross-examination of Michael Proctor. We started already in day 22 with the direct examination of Michael Proctor, and we just began a little bit of the cross-examination. And let's just remember that a lot of those text messages came out on a direct examination when the prosecutor was actually, this is the Commonwealth, the prosecutor, Mr. Lally, was asking Michael Proctor about these inappropriate, these really disgusting text messages that he sent about Karen Reed to his friends. And this is an investigator. He's leading this homicide. He's the lead detective, the person who's supposed to be in charge of all this. And this is how he's talking about the suspect in this case. So very unprofessional, and the jury certainly did not like that. Now, of course, this had to come out during direct examination. I explained this already, and if you're a good attorney, you're smart, anything that's negative about your case, you are going to personally bring out, and you're going to try to spin it in a way that is at least not as damaging to when the jury hears it, as opposed to coming out during cross-examination. So that we already explained. That's why Mr. Lally definitely did have to bring out these text messages on his direct examination and not wait for Alan Jackson to come down and just smash him with these cross-examinations. So that's why it had to come out. And also part of what's going on here is that Michael Proctor is going to try to play down his role as the lead investigator in this case. And the reason for that is that if the jury believes that this is the lead investigator, this is the lead detective, this is the guy who's he's calling all the shots, and this is a guy who's talking this way in text messages, how it's so inappropriate and disgusting, then it's much easier for the jury to say, this guy is so gross and disgusting that I'm not going to trust anything that he did. I'm not going to trust the investigation that he did. And therefore, we're just not going to find Karen Reed guilty, no matter what other evidence says. But if you're able to play down his role and say he's just one piece of the pie, there's many different pieces here that a lot of detectives work on this case, a lot of police officers worked on this case, a lot of experts work on this case, and he's just one piece, one insignificant piece. So yeah, you're never going to have everybody perfect, and this is just one guy. So it's much easier for the jury to say, okay, it's one guy who's acting inappropriately, and let's not discount the entire investigation because of it. So that's why we're finding that Michael Proctor is trying to play down his role as the lead detective in this case. He's trying to just say, no, this is just a collaborative effort. We're all here on this together. We're all making decisions together. It's not just me. And really, though, it seems, as the defense brought out, that no, really, he really was more in charge than other people. He's trying to play it down, but the defense is obviously trying to show how he's really the one really much more in charge. And the reason is, as I explained. So let's continue with the cross-examination that Mr. Jackson was going with Michael Proctor. So he went back to the text messages which he had with his group, his high school friends, and this was on January 29th. So the first day of the investigation, 16 hours into the investigation, essentially, that's when these text messages were being exchanged. And in those text messages, somebody said that I'm sure the owners of the house will receive some SHIT for this. And his response was, nope. Guys, the owner of that 34 Fairview was a Boston cop. Now, he tried to explain this. Michael Proctor tried to explain this, that actually was not a reason why he's not going to get any slack for this, or SHIT for this. It's not really a reason. He just happened to be sharing that information that by the way, he's also a Boston cop. But the reason why, in Michael Proctor's world, this is his explanation, the reason, to explain the text, the reason why Brian Albert's not going to be implicated in this is because he's not. The evidence just doesn't point that way. That's why, nothing to do with him being a Boston cop. So that's what he's trying to explain. But the text messages certainly looks like, nope, he's not going to catch any flack for this because he's a Boston cop. But he tried to explain it away, and that, I can tell you, didn't sit well with me, probably did not sit well with the jury. It certainly looks like he's saying he's not going to catch any flack for this because he is a Boston cop. Now, he also acknowledged at this point that this is only 16 hours into the investigation. This is the point that Alan Jackson made. And by this point, he only questioned 3 people. He only interviewed 3 people, 2 of them with the names McCabe, and 1 of them, Brian Albert. And he's already coming to this determination that Brian Albert cannot be implicated in this case. Now, he also at some point responded also in another derogatory explanation in how John O'Keefe died. He says that she waffled him and that he saw his body at the hospital. And somebody even asked, what does it mean waffle? Did she waffle him? And he said, yeah, he was banged up. And again, here we have Alan Jackson asking, did you have this case all wrapped up by January 29th at 10 p.m.? And he says yes. And then we have a very interesting exchange. We have an exchange where this guy, Bird, asks, so the owner of the house was a woman cop who beat him. This is what I guess Bird thought. And Michael Proctor responds, that's what I thought initially when I talked to the Canton paramedics. So here you have Michael Proctor saying initially he thought that, yeah, this was an altercation. And when he spoke to Canton paramedics, that's also what he thought. So again, it seems that not only does Michael Proctor feel this way, but also the Canton paramedics felt initially, at least, that this was due to an altercation. Now, I want to play you a small clip, which people have been asking me about the judge. What do I feel about the judge in this case? Is the judge being fair? Is the judge being biased? People are saying that the judge is biased in this case. I haven't seen tremendous bias. Now, I do have some issues with how certain things are being run. I don't like the way that objections are being handled. I don't like that there's no explanation of objections. There's no explanation for the rulings. I don't like any of that. As an attorney, I think that the more of a record you have is helpful. Now, of course, there's a fine line between having a record for what the basis of your objections are and the basis of your rulings are, and getting through speaking objections and arguing objections, and then you're giving too much information to the witness or to the record or to the jury that they're not supposed to hear. So of course there is a fine line here, but like what I've spoken about before, I don't really like the way that objections are being made, and this seems to be the way that this judge wants to run the courtroom. You just say objection without giving any sort of reason or rhyme for your objection, and she just makes a ruling without giving any sort of reason for it. And some of the objections I can follow, and some of them, quite frankly, I don't understand the basis of the objection, and I don't understand the rulings. And maybe all the attorneys do understand it that are trying this case. I don't. So I would have liked to hear some more about that in terms of the objections. So I'm not seeing any direct bias by this judge. Now, yeah, certain questions I felt like should have been able to have been asked. Like I didn't feel that she should have sustained certain objections, but some of the objections I don't even understand. So there could be a lot of things that we don't see. There's some motions that were filed or some sidebars that they spoke about with certain pieces of information that could potentially not be allowed to come in, or they have some other agreements about. So I can't just tell you based on my feeling that certain questions should have been allowed to have been asked and the fact that she's sustaining certain objections. But I want to show you this one clip where I feel that, again, it doesn't show bias, but it's something that I don't like that the judge did or how she handled this specific back and forth. So let's take a look at this clip, and then I'm going to explain a little bit more.
So what you meant by that, Trooper Proctor, was according to you, based on your initial conversations with the paramedics, the first responders, you were under the impression that this was a beating death. He'd been beaten to death, correct?
The way it was given to me, sir, was
That's yes or
medical.
No? That's yes or no?
He's going to answer the question.
All right. So let's break this down for a second. Alan Jackson asked a question. He said, initially, you were under the impression that this was a beating death. Essentially, that's what he was saying, right? He's trying to establish that Michael Proctor initially thought that this was that John O'Keefe died because of an altercation. That's really a yes or no question. You can answer with a yes or no. And that was what he was doing in cross-examination. Now, Michael Proctor doesn't want to say yes or no. He wants to explain, right? And that's really more in the area of redirect. So if Mr. Lally wants to open up this again on redirect, he could say, okay, you've said yes or no, however you answered that question. Now, can you explain a little bit more to the jury why you're saying that, or what changed in your mind, or just explain a little bit more? That's for redirect. Cross-examination, and this is completely understood. Cross-examination, You can be asking yes or no questions and getting yes or no answers. Now, a lot of times the witness does not want to answer it, but a good attorney is going to stop the witness and say, excuse me. Now, there's different ways to do this, but one of the ways is that the witness goes on and on and he says, excuse me, sir, you're not answering the question. Can you please answer the question? Let's concentrate on the question again that I'm asking. The question that I asked was, initially you thought this was a physical altercation, right? It's a yes or no question. And I would say to the witness, if this was me, I would say, and if you feel that you can't answer this question, this very simple question with a yes or no, then just say, I can't answer this question with a yes or no. Okay, that's good enough for me. Because then either you get your answer or you see very clearly that he doesn't want to answer it and he's refusing to answer it, and the jury sees that he doesn't want to answer the question, even though it's very easily answered with a yes or no answer. And here, he's trying to explain. So what would happen a lot of times is when you'll tell the judge, if you're the attorney there, you'll say, Your Honor, please instruct the witness to answer only the question that's being asked and not to give these lengthy explanations that have really nothing to do. I'm not asking for an explanation. And the judge a lot of times will go on your side and say, yes, this is cross-examination. This is how this works. This is how this works in cross-examination. You can ask questions a certain way and get certain answers without explanations. And then if on redirect, the other side wants to open this up, they can do that. And a lot of times the judge will side with you on this. And in this specific instance right here is where the judge says, no, Mr. Jackson, you're either going to withdraw the question or you're going to let him answer the question how he wants to answer the question. And I would be extremely livid at this. And Mr. Jackson has a good way of staying calm throughout all of this. A lot of this that's going on, he's not flustered at all, and he's not losing his cool at all. And I got to give it to him for that, because some of these things, and again, I don't know what's going on when the cameras are off, but certainly I'd be making some records when the jury's not there, just so I don't have to do this in front of the jury. When the jury's not there, I'd be making records with the judge and saying, Your Honor, I asked a simple question. It was a yes or no answer. The witness tried to explain. And if the witness wants to explain, that's perfectly fine on redirect. That's not my question. And Your Honor allowed him to answer a question that was not asked of him. This question was not, I did not ask for an explanation. I asked what he initially thought. If he can't answer the question with a yes or no, then he can say, I'm sorry, I cannot answer that question with a yes or no. And then we'll move on. Or if I want an explanation, I'll ask for an explanation. But I didn't feel that this was appropriate for the judge to interject on her own without any objection. To interject on her own and tell Mr. Jackson that he either has to withdraw the question or that he has to allow the witness to answer a question that was not asked of him. So I would be huffing and puffing and trying to control myself at the counsel table. And obviously, of course, when the jury's there, I do my best to do that. But I would certainly have a record to make when the jury's not in the presence. As a matter of fact, I may even say at the time, Your Honor, I need to make a motion out of the presence of the jury right now. Can you please excuse the jury? Because if you finish with this witness and then the jury's out and then you make your record, well, the witness is already gone, and you can't continue making your record. So you may have to sometimes say, Your Honor, I'd like to make a motion. I don't want to do it in front of the jury for obvious reasons or for reasons that I don't want to disclose right now. We can have a sidebar, and then she may call you to sidebar. And then you can say this at sidebar. You can say, Your Honor, what just happened here was inappropriate. I think that that's improper. This is cross-examination. I'm allowed to ask questions a certain way, and the witness is not just allowed to give any answer that he wants. And if you allow the witness to do that, then how am I going to ever effectively cross-examine in this case if every time I ask a question, you're going to allow the witness to answer however they want to? So this was an area where I thought, I was like, whoa, this is just, again, I don't think it's showing bias. I don't think that I'm going to say that this is a biased judge. I just don't think that it was the right ruling, okay? And that's just my opinion. It's my opinion. And like some of the other objections that I'm finding throughout this case, which I don't necessarily agree with the ruling. So this is just one specific thing that just really, really stuck out in my mind. All right, now let's move on. So getting back to this actual, what he initially thought. So Michael Proctor tries to take back what he initially thought, but Alan Jackson eventually does a good job of getting him to stick with his text messages that, yeah, he did initially think that this was, that John O'Keefe died as a result of an altercation. He also acknowledged that there's no bruises below the neck. And this is going to be a question that the jury is really going to have to struggle with. If this is what happened, by the Commonwealth, according to the Commonwealth, that Karen Reed hit him with a car. Why are there no bruises below the neck? All right. Now, it's going to be some sort of a side swipe we're going to hear about a little bit later, and maybe that's what happened. He just was hit by his arm, essentially, and then he flipped around backwards, smashed his head on the curb. But this is a very fair point, that there's no bruises below the neck. And then he continues. He says, have you ever seen pedestrians hit by a car without bruises below the neck? And this is really Michael Proctor opened the door, because he said that he did investigate other pedestrians, other accidents where pedestrians were hit by a car. So he said, have you ever investigated a case where pedestrians are hit by a car and you don't see any bruises below the neck? And he tries to get out of this also. He tries to say, well, I really investigated more of like high speed accidents between pedestrians and motor vehicles. So I can't really tell you, here was a lower speed, like 24 miles per hour, which we're going to see soon. And therefore, he can't really give a good opinion about whether there should be bruises below the neck or not. He said, but then he got himself into a little bit of a jam, because Alan Jackson did a great job. He pointed out the fact that, hold on a second, you just told me before that one of the big reasons in this case, that you feel that this was a car accident and not an altercation, what changed your mind, what you initially thought, was the fact that you found a shoe, right, by the curb. And in your experience with these pedestrian versus car accidents, it's very common for a person's shoe or an article of clothing to be stuck at the scene of at the point of impact, and then discovered later, or thrown off the person. But it's at the point of impact. But if that's true, then at the point of impact, you've only investigated cases where there's high speed, 60 miles per hour. And maybe that's where you find only one shoe. But if you've never investigated cases where there's a low speed impact with a car versus pedestrian, how can you say that you're so sure now, or that you're convinced the fact that there's one shoe at the scene, that this is actually as a result of a car accident? Because you've never investigated low speed impacts like this. So that was something also Mr. Jackson was able to bring out. Another thing that he brought up was that Michael Proctor texted in one of his texts that he would not be able to prove whether this was intentional or not. So even assuming that this was John O'Keefe died because Karen Reed hit him with a car, he would not be able to prove that Karen Reed acted intentionally. He said that in his text, this is something we're not going to be able to prove. Now, full stop. She's being charged with second-degree murder. Okay? That is an intentional act. And here, in order to find second-degree murder, it's intentional killing. So now here, Michael Proctor is saying in his text messages right away when he says, yeah, it's all Karen Reed, but there's no way to know that she acted intentionally or not. That's his opinion. And that just completely shuts the door on a second-degree murder charge. And this is something that Alan Jackson pointed out. So he continues, and there's some more text messages, and he says Michael Proctor texts that the Boston Police Department and Canton had to recuse themselves, and he knew this 16 hours after the investigation already started, so that he knew that Canton would have to recuse themselves. And again, somebody else, one of his friends texts in this group text, but I assume you guys are out to make it cut and dry since it involves cops. And this is kind of what a lot of people understand. When it's cops involved, you want it to be cut and dry. You want to stick it on one culprit. You don't want anybody else implicated, and you want that person to fry. That's what you want. You want justice. Like it's one cop. You want to wrap it up, cut and dry, finished. And then somebody else sent the text, something stinks. And let me tell you, if Alan Jackson has this, a printout, and I'm sure he does, if he has this printout of this text message, this has got to make it to the closing argument. This specific text, I'd have it blown up. I said, this is exactly what's going on here. Something stinks about this case. And this is what his own friend, Michael Proctor, knew. The day of this investigation, he knew that something already stinks. All right, anyway. So Michael Proctor texts again. He says, yes, but there will be some serious charges brought on the girl. So again, this is 16 hours after the investigation got started, and he already knows that there's going to be serious charges brought on the girl. So really, really looks like they're jumping to judgment here. Then somebody texts the inappropriate parts, and of course, Alan Jackson is going to go over this a lot of times so that he can show how inappropriate he was acting. Somebody texts, "She's hot at least," and this is what his response was. From all accounts, this is Michael Proctor. From all accounts, he didn't do anything wrong. She's a whack job, CUNT. And then here you go, by all accounts. And Alan Jackson pointed out, wait a second. This is, again, not by all accounts. This is by the accounts that the 3 people that you chose to speak to within the first few hours of the investigation, 2 of them happen to have the last name McCabe, and one of them is Brian Albert. So stop with your all accounts. Oh, yeah, by all accounts, all of this lengthy investigation, all accounts prove that the owner, Brian Albert, had nothing to do with it. So, yeah, and then he responded, "Yeah, she's a babe. Weird Fall River accent, though." And then no ASS. Again, very inappropriate. Someone writes, "Oh, she's skating." And then Michael Proctor writes, "0 chance. She's skating. She's effed." So it just really, I mean, you don't need any explanation for these texts. All right, and then we have him even laughing at one of the texts that Bird wrote back. "Good, no ASS, BITCH." So again, and Michael Proctor is laughing at that text. So really bad. And then we got some more text about Michael Proctor talking or making fun of Karen Reed's medical condition, that she has what he called a leaky balloon knot, and it's just gross. I mean, it just really makes your stomach turn. And Alan Jackson did a good job. He told Michael Proctor, "Now explain to the jury, what does a leaky balloon knot mean?" So he's really bringing out exactly what he needs to. And then he brings out this fact. I'm Alan Jackson. "You're aware that she had a colectomy surgery, 10 surgeries in the span of 18 months. Are you aware that she had some serious issues and that she needed 10 surgeries in the span of 18 months? And why is he bringing that out? Does it really make a difference how many surgeries she had? It doesn't really make a difference. It's not really so relevant to the case at all. But of course, he's able to get it in, and of course he's trying to invoke some sympathy with the jury, that here you have this poor girl, Karen Reed, who's going through all these terrible stomach problems, and she's had to have 10 surgeries over the span of 18 months. And here you have this conceited police officer who's completely making fun of it. Nobody wants to have their medical conditions made fun of, especially when they're the suspect of a case. All right. Then he brought up the fact that in February 2024, in the federal grand jury, which they never refer to as the federal grand jury, they just say in a different proceeding, Michael Proctor testified that he did not know any members of the Albert or McCabe family. That's essentially what he testified to. Now, he tried to get out of this artfully, but he was really grasping at straws in order to try to get out of this. And then, of course, he had to acknowledge that Courtney Proctor, who's his sister, is close friends with Jillian Daniels. Jillian Daniels' sister is Julie Daniels. Julie Daniels is married Chris Albert, so now Julie is Julie Albert. And, of course, there is some connection between Courtney Proctor and Julie Albert. And, of course, Michael Proctor knew Julie Albert. So how can you tell in the federal grand jury when you're under oath that you didn't even know or have a relationship? And this is where he tried to get out of it. Well, there's a difference between no and relationship. I was saying no to one thing and relationship to another thing. It really did not, I don't think, was bought by the jury. He lied, and he tried to play it down. All right, and then Alan Jackson showed some text messages between Courtney Proctor and Michael Proctor. Number one, about Julie Albert perhaps babysitting for him. Also, the fact that he was interviewing Julie Albert, he was in touch with Courtney Proctor about that, his sister, and Courtney Proctor texted him, "Oh, she was so scared about it, she was so nervous," and he was like, "Don't worry about it. It was a quick conversation, like quick convo, nothing really to be worried about." And again, it shows that he's not really taking it too seriously. Courtney Proctor also texted Michael Proctor that she was going to actually meet with Julie Albert before Michael Proctor interviewed her. Now, another thing that Alan Jackson brought out from Michael Proctor is the fact that Colin Albert's name does not appear in any police report until July 18th, 2023. And they're making a big deal about this because Colin Albert was technically at the home that night, although from the accounts and the testimony that we heard, he left before anything happened. And that's the excuse why he wasn't listed in any report. It's a pretty good excuse, I think. Like if you buy that testimony that he really left before any of the action happened. So that's why he does not appear in any of the reports. Okay, it's a good, it's a decent point. It's not like a home run, So now he asked Michael Proctor, did you look at the Life 360 app? As we've heard about before, the fact that Allie McCabe picked up Colin Albert, and their story was that she just picked him up and brought him home. And it seems from the Life 360 app that Allie McCabe did not go straight home. And he was asking him, did you look at the Life 360 app? He said no. Now, in order to get some of the footage in this case, he reached out. Michael Proctor reached out to an officer, Galanis, who he knew that was from Canton Police Department. So here, that the Canton Police Department is recused from this case, and you're asking them for assistance. Doesn't that look inappropriate? That's inappropriate also. So he pointed that out. Also, the fact that Lucky Loughran, the plow driver, Alan Jackson brought out that Michael Proctor only interviewed him, Lucky Loughran, after the defense brought it to his attention that Lucky Loughran actually plowed 34 Fairview that day. And Michael Proctor's response was, well, I thought, from Michael Trotter, who was the boss of the supervisor of all the plow drivers, he understood, this is Michael Proctor's testimony, that he understood that really they were only concentrating on the main roads, and they were not going down private individual roads like 34 Fairview. And therefore, that's why he didn't even interview Lucky Loughran until later. And Alan Jackson brought out that, do you realize, or do you understand that Michael Trotter actually testified that he told you that Lucky Loughran was plowing 34 Fairview that morning? And he said, obviously, no, he didn't know that. Now, another thing, the fact that Brian Higgins brought an extraction of his text messages to Michael Proctor himself. And Michael Proctor testified in a different proceeding that no one ever in his career took it upon themselves to extract their own phone and give that extraction over to the police. He said it's never, ever happened in his career. He also testified that he didn't get a search warrant for Brian Higgins. So again, it looks like Brian Higgins is either hiding something, or it just looks like this is very, very strange that it's happening. All right. Now, he also testified that he didn't get a search warrant for Brian Higgins' phone. And then he gets into the medical examiner's determination. So we have on April 28th, 2022, the medical examiner said that it was undetermined. Now, of course, Michael Proctor tried to stick to the story that it doesn't really matter what the medical examiner decides. He is always going to continue his investigation from what and follow the evidence, whether the medical examiner rules this as a homicide or not. And he tried to kind of back that up. But of course, and it's not lost on the jury, I'm sure the jury understands this, that of course, having a medical examiner determine that this was a homicide, obviously, helps the case, and that's something that you want as a police officer. He tried to play it off as, it doesn't really matter what they say. Of course, we have to assist with them. We're required under the statute to work with them and give them the facts that we know. We're just fact finders, and of course, whatever the medical examiner determines, that's fine with us. We don't really care. It doesn't really affect our investigation one or the other, but everybody understands that, of course, it does. All right, so Michael Proctor also said that the medical examiner is a whack job. So everybody's a whack job in this case. Karen Reed's a whack job, according to Michael Proctor. The medical examiner is a whack job. Everyone's just a whack job if you don't completely follow the view of Michael Proctor. Again, another thing that he said in the federal grand jury is that he's never really seen that before in a homicide, where the medical examiner has an undetermined, where the medical examiner determines that this death is undetermined, and it's a homicide. So he said he's never really seen that before in homicides. Of course, it does happen, but he's personally never seen that. And then they go through again the text messages between Trooper DiCiccio and Michael Proctor about that determination, and DiCiccio is busting his chops for it, that he couldn't get the medical examiner to say that it was a homicide. He also testified that he was not aware that certain text messages or calls were deleted from Jennifer McCabe's phone. He also shows some text messages between Kevin Albert and Michael Proctor, and they are coordinating witness interviews. And again, this is the Canton Police Department, who's supposed to be completely recused from this case, and because of it, Kevin Albert. For crying out loud, this is the reason why Canton Police Department is recused from this case, because of this individual. And this is the individual that you're deciding is going to help you coordinate interviews? You've got to be kidding me. All right. Anyway, but that is essentially what he's bringing out. That's Alan Jackson's bringing out, that you're coordinating with Kevin Albert about this. All right. Now, he also did a great job in tripping him up here. He really tripped him up here. Alan Jackson did a great job in cross-examination of Michael Proctor. He tripped him up here by showing that he actually got him to admit on the stand that the reason that they didn't use one of the recorded rooms in the Canton Police Department, right? In the Canton Police Department, there's different interview rooms. Some of the rooms are recorded. So everything that goes on in that room is recorded. We've seen those recordings, heard those recordings before in other cases. And he asked him, did you use any of those rooms? And Michael Proctor's answer was no, because the Canton Police Department was not supposed to have a recording. They were accused from the case. So we kind of got him to admit, oh, wait a second. So you're agreeing that they're accused and therefore they should have no recording and they should also not have anything else to do with this case, right? But he tries to walk that back as well. Now, we have this other case that Michael Proctor was working on with Kevin Albert. And July 19th, 2022, when this other investigation is going on, Kevin Albert is working on a cold case with Michael Proctor. And they're working together. And they're going out drinking together. So you're really, really seeing a connection there between Kevin Albert and Michael Proctor. And at one point, Kevin Albert left his badge in Michael Proctor's cruiser and couldn't find his gun. And he tried to say, well, he doesn't really remember them drinking that much. He only remembers a few beers. But then he pulled out a text. Alan Jackson pulled out a text July 20th, 2022, which shows that Kevin Albert is saying how hungover he is. So was that a couple beers or was that because you guys got really drunk? All right. And then he goes back to the fact that there's no evidence log between January 29th, 2022 up until March 14th, 2022. So the first log for the evidence log for John O'Keefe's clothing is March 14th, 2022. And they were in possession of his clothing from January 29th, 2020 through March 14th. From January 29th through March 14th, they had, or at least Michael Proctor had access to John O'Keefe's clothing. And the first log is March 14th, 2022. And then he also pointed out that the affidavits that he signed, that Michael Proctor signed, all say that Karen Reed's car was seized at 5:30 p.m. And really, he seized the car at 4:16 p.m. A good hour and 15 minutes before that. He also acknowledged that when her car was seized, that was before any pieces of taillight were found. So again, showing that it's possible that you guys took the car and all of a sudden, pieces of taillight started showing up. What do you think happened? Now, there was a point in where Michael Proctor said and acknowledged that he was just following orders. Now, it wasn't with reference to everything going on in this case, but he did say it about one specific area. And I thought that was an interesting verbiage, that he was just following orders. And I think the defense could have done some stuff with that, and maybe they will in closing arguments, that he was just following orders. All right. Now, he also pointed out that there's two garages that the Massachusetts State Police had access to and could have brought Karen Reed's car to, and instead, and were close, right, they were closer to Karen Reed's car, and instead they brought it to the Canton Police Department Sallyport. So that looks very strange. You've got two closer Massachusetts State Police garages, which they could have brought this Karen Reed's car to, and instead they go to a further one away that just happens to be the Canton Police Department, which is recused from this case. They bring it to their Sallyport. Now, it may sound like a strong point, but as we'll soon see, and what I think we've kind of heard about already, was the fact that it's not such a great argument. And the reason for that is that it's going to come out that the Sallyport in Canton Police Department was the only one that's big enough and was heated. And it's the middle of the winter. You want the snow to melt. You want it to be a workable environment. If it's freezing in there, it's going to be hard for people to look at the evidence in for the car and the tail light. And, so there is a very good explanation for this. So whether it's worthwhile for the defense to bring out this point is questionable. I don't know if I would have, because there's a really good explanation. But anyway, still, again, showing the connection between the Canton Police Department, even though they're supposed to be recused from this case. Now, another part is that there was a lot of surveillance footage that was turned over in this case during discovery. There's something like 360 videos that were turned over from discovery. And isn't it interesting that the Canton Sallyport surveillance footage was not turned over in one of those videos. It's really strange that it wasn't turned over. And that's a point that he made. And he said that he wasn't aware of it. And Michael Proctor said he wasn't aware of it. And then Alan Jackson showed that in his federal grand jury, again, he's not allowed to say federal grand jury, but in that proceeding, in February 2024, he was asked if he knew about the video in the interior of the Sally Port, and he said yes. So, again, he tried to explain away what he knew. He says, no, I knew about the outside one. I didn't really know about the inside one. I knew that the vehicle was in Sally Port. He tried to explain this way also. Again, didn't really, I don't think, worked too well on me, and probably I don't know if it worked on the jury either. And eventually he did turn over the grainy video, as we saw the grainy video. And, of course, on that video, it's missing the precise time when the vehicle was being delivered to the garage. And he said that he was just really made aware of the second video in the Sally Port garage a few weeks ago after trial started. That was the first time that really Michael Proctor knew about that other video that we all saw, the inverted one, the mirrored one, all that stuff that we saw already. And he only became aware of that very recently. That was not one of the videos that he decided not to turn over with all the other 360 videos. That was Michael Proctor's testimony anyway. Now, he also acknowledged that he had a way to access John O'Keefe's ring videos. And we're not going to hear that Karen Reed had any access to that yet. We haven't heard that yet. That Karen Reed had any sort of access to those ring videos. But Michael Proctor acknowledged that he did have access to those ring videos by John O'Keefe's house. And if he had access, that means he could have deleted any of those videos. But he claims that, of course, he did not delete any of the videos. Now, there was a sticky note from Trooper DiCiccio after reviewing some of the ring camera footage, and this is what it said: 1241 taillight from driveway, I think she arrived home. So what does that sticky note mean? That means that he was looking through the ring footage, and it can mean one of two things. Either it means that, where is it? 1241, she arrived. Where is that video? Or it means, I'm actually looking at that footage, and that's something that you should know about, and that he deleted, or all of a sudden magically got deleted. So there's some questions about what exactly the sticky note meant. Now, on June 1st, 2022, when Michael Proctor wrote a report, and in that report he wrote about what some of the times that were significant to him from the ring footage, he doesn't put in 1241 at all. He finally says that Karen Reed was really treated as the same as all the Alberts. Everyone was treated the same in this case. He was fair to everyone. And finally, how Alan Jackson finishes off cross-examination, which is a really strong way to finish off. He brings up a text that Michael Proctor texted that hopefully, when referring to Karen Reed, hopefully she kills herself. And obviously, the jury is not going to like that text at all. And before he sits down, Alan Jackson says, "Shame on you." And of course, the judge says, "Excuse me, we're going to stop with those commentary." And she's probably told him 100 times not to use any commentary in this case. And that was something that we're all told. Don't just comment and have a running commentary. That you're supposed to ask questions to the witness and not comment on the testimony. That's for closing arguments. But nevertheless, he still wanted to say that, and a great way, strong way to end the cross-examination. So there's some redirect, but we've already went through most of the direct examination, some of the cross-examination, and really nothing too exciting, really, so much on the redirect that we haven't really heard what the prosecution and the Commonwealth's case is going to be and what their argument is going to be about Michael Proctor. All right, so Michael Proctor is done, and if they just had to hang their hat on Michael Proctor, the jury is probably nobody knows what the jury's going to do, but it would be difficult probably for a jury to come back with a guilty verdict just based on Michael Proctor. So really, I think the ultimate question is going to be is how much weight they give to Michael Proctor. If you have to trust a lot of what Michael Proctor is doing, then you're going to have a problem. But if the state and the Commonwealth, the prosecutor, can point to all the other pieces of evidence and all the other people that testified, and you can point to all of them and say, look, Michael Proctor was really had very, very little to do with the case. Yeah, he ran the case, but this case is all about all these other witnesses and all these other pieces of testimony. You're going to get a lot further with the jury, and the jury hopefully, I mean, if you're on the Commonwealth side, then you're going to ask the jury that, yes, these texts were inappropriate, they were juvenile, he should have never wrote these texts, but all this investigation had to do with all this other testimony, all this other evidence. So that's probably how the closing argument is going to sound when it comes to Michael Proctor. Then we heard from Lieutenant Tully. Lieutenant Tully said that even though, again, he's a lieutenant with the Massachusetts State Police, and I thought Lieutenant Tully came across mostly as believable, an upstanding person. It didn't seem like he was trying to get out of too many things. There's, I think, one area which I keep hearing about, which I don't love the way that the state is approaching this and how the witnesses are talking about it. But I think in general, I think the impression that I got from Lieutenant Tully is that he's a good guy. He takes his job seriously. He's trying to do his best, and not like Michael Proctor came across. Now, he testified that even though the Canton Police Department were recused from the case, that it's still normal to receive some support from the Canton Police Department in arranging certain things and getting certain things done. He also testified that he spoke to Trooper Michael Proctor about those text messages and how he was admonished by him, and he reported it up to the chain of command, showing that this is not okay. We are going to take measures against him, and I don't agree with anything that he did. So showing that he is the adult in the room, right? All right. He also testified that he took some pictures of the broken taillight, the black sneaker, and it matched the sneaker in the hospital. And then he testified about him being the only, not the only evidence officer, but there's only a few evidence officers in the Massachusetts State Police. So only an evidence officer has the access to the permanent evidence storage area. And Michael Proctor was not one of them. So there's only 3 people, Lieutenant Tully being one of them, who had access to the permanent evidence storage area. And therefore, if you are a guy like Michael Proctor, what you have to do is you have to put the evidence in a temporary evidence storage area, which we heard a lot about. And then at some point, whenever one of the evidence officers are around, one of those 3 people who have access to the permanent evidence storage room, they're able to transfer the evidence from the temporary storage room to the permanent storage room. He also said that evidence labels can only be created by the evidence officers as well. Now, something else that he pointed out, which is a very, very important part, because one of the big questions in this case is the fact that there is no log about what happened with John O'Keefe's clothing from January 29th to March 14th. It started getting logged in the permanent evidence locker or permanent evidence storage room, wherever that permanent evidence area is. It only started getting logged on March 14th. So what happened from January 29th to March 14th? There is no logs of this at all. And here you have Lieutenant Tully testifying about this. And he said the reason why there's no logs for that is because there's no need for it. There is no need for it. And in fact, he tried to say that there's no policy. Policy does not require this. And this is something that you find a lot of times in civil rights cases. You find about when they're talking about policy. And there's these policy pamphlets and policy booklets. And the attorney should be knowledgeable about the policies. If he's going to refer to some policies, then they have to be familiar with some of the policies there that he's referring to. And then you can talk to him about the policy. So essentially, he's saying that there's no policy that you have to log anything from temporary evidence until it gets into permanent evidence. Once it gets into the permanent storage, that's when the log begins. And that's what policy dictates. So they're just following policy, right? And that was his. Now, I don't think that this was addressed at all in cross-examination. And I think, number one, you could have discussed the policy. Number 2 is just to make the point. Hold on 1 second. Are you telling me there is no policy at all? And this is what you're telling me is reasonable. I mean, you're following the policy. There's no policy that when evidence comes into a police station, before it becomes into the permanent evidence storage room, there is no log that's necessary at all. That evidence can just sit in the temporary evidence room for the next 3 years without anybody making any sort of notes about it at all. That's policy? Okay, I just wanted to make sure. Right? It sounds ridiculous. Nevertheless, that's what he said. And I don't think that was addressed really in cross-examination, which I think could have been. Now, he also testified, this is going on to day 24 now, by the way, so we're on to day 24. He also testified that he never searched 34 Fairview. And this is really what everyone keeps sticking to, and this is the only really the problem that I think Lieutenant Tully himself didn't really believe. Everything else I thought that he was a really believable witness, but this specifically is where you get the problems. Okay, everybody starts, when you start asking, well, was there any search warrant that was even applied for 34 Fairview? And everybody says no. Everyone keeps saying no. All the police officers, no, there's no probable cause. There's no even reason to even attempt it. There's just, and that's what he's saying. He's saying there's no evidence. There was never a search in 34 Fairview because they never had any reason to believe that there would be evidence at 34 Fairview that's connected to John O'Keefe's death with him dying on their front lawn. Okay, that was his testimony, and that's really the only problem that I have really with his testimony. Every other part of his testimony I think was fine. I mean, he came across at least I think fine. He also acknowledged that he made the determination to send that SUV to the Canton Police Department Sallyport, and he said because it was large enough and it was heated, so he explained that very well, and therefore any argument about why didn't they send it, give it to the other areas and put it into the other garages, it all falls flat. Now, he also acknowledged, for the first time, we have one police officer who's acknowledging that it's not just the interviews that Canton Police Department were recused from. Finally, someone who's making some sense, because I've been talking about this throughout this trial, that it makes no sense that you're just recused from performing interviews, but everything else you can do. It doesn't make any sense. So here, finally, Lieutenant Tully, the adult in the room, is telling everybody, yes, the Canton Police Department was essentially recused, and this is what he said, essentially recused from the entire investigation. So let's put that to rest. And this is, again, a point that you still can make in your closing arguments if you're the defense. You can be saying, look, we've heard from this officer, that officer, this officer. They all said that the Canton Police Department is only recused from interviews. And you all knew how ridiculous that sounded. Finally, we got Lieutenant Tully to finally come clean. But you're still showing how everybody else is trying to hide stuff and trying to play down things. But he did say this, and therefore I think this is what makes the most sense, that they were accused from the entire investigation. Now, he also tried to say that, or he did testify, that the abrasions on John O'Keefe's body was consistent with some of the dimples, what you called, on the taillight. Right? Those abrasions on his arm are consistent with some of those dimples that we find on the taillight, which one of the pieces of evidence that he collected. Now, he also acknowledged that from 12:33 a.m. to 6:03 a.m., Karen Reed made 53 phone calls to John O'Keefe. So if this is someone who intentionally threw the car in reverse with every intention of killing John O'Keefe, would she then, and left him there to die, would she then call him 53 times? Maybe just she's not 100% sure whether she finished the job. So that is really more conduct that we see would make more sense for a person who doesn't really know what she did. She's not sure. Maybe she wanted to hurt him, even if you buy that story. Maybe she wanted to hurt him, but did she actually know that she was actually trying to kill him? Why would she expect him to answer the phone? Unless this is all part of the game. Let me make it look like I'm really frantic about it. Now also, there was some interesting part here about the surveillance. The surveillance from Karen Reed the next morning at 5:18 in the morning, when she's driving around and she calls Jennifer McCabe, right? We heard about that. And she's going to go pick up Jennifer McCabe. Now, there's some surveillance showing Karen Reed driving her vehicle at 5:18 a.m. Now, she didn't arrive to Jennifer McCabe's house until 5:35 a.m. And he was asked, how long would it take from where we saw Karen Reed's vehicle on the surveillance, how long would it take her to get to Jennifer McCabe's house from that area? So 5:18 a.m., she's driving in a certain area. How long would it take to get to Jennifer McCabe's? If that's where she's going, right? That's what you assume. She wakes up, she's frantic. She just wants to get to Jennifer McCabe to help her to locate John O'Keefe. How long would it take? Only a minute or two, 3 minutes, 4 minutes. Definitely not till 5:35. So the suggestion here, which I picked up on, I think, the suggestion here is that she was going to 34 Fairview, that she went there first. That's where she went there first, to see John O'Keefe, to make sure that, I guess that's where he was, and that's where she left him to die, making sure that that's where he was, and then going back to Jennifer McCabe's house. That's what I think the prosecution is trying to show over there. Now, on cross-examination, Alan Jackson points out that, hold on a second, you're telling me, and this again, this is the part where I think, even though they're all sticking to their story, it has some really significant weakness to it. The fact that they didn't get a search warrant on 34 Fairview. when a person ends up dead on their front lawn. Okay, just think about it. Just think about it. And remember, this is an argument that you can make to the jury. Jurors, you're allowed to use common sense. You don't have to know every policy and every training that a police officer went through. Use common sense. Somebody ends up dead on the front lawn of somebody else's house. Do you think for a second that person's house is not going to get searched? It just so happens in this case that it wasn't, and it just so happens that the person who owned that house was a Boston police officer. Now, this is the point that everybody keeps doubling down on, and this is the point that Al Jackson keeps bringing up. So again, he says, you knew that John O'Keefe was invited to the house at 34 Fairview, right? Right. You know that he wasn't wearing a coat. Wouldn't that suggest that he came from inside the house? You knew that he wasn't wearing gloves or a hat. Now, of course, we've heard some testimony that John O'Keefe didn't like to wear that stuff, but if you don't know all that stuff yet, you're just coming first to a scene. You see a guy without any clothes on, without any coat on, without any gloves, without winter gear, and he's right outside a house dead. Isn't there some suspicion there that maybe he was beat up inside? And then you also see that there's consistent, according to the paramedics and the first responding officers, that his injuries are consistent with a physical altercation. Yeah, of course, the altercation does not have to come from inside the house, and that's what Lieutenant Tully said. Yeah, it doesn't have to come from inside the house. You're right, but is there a reasonable suspicion that it did? Sure. But again, no probable cause. And he also said, you could have also asked for consent. This is a fellow police officer, right? This is a person who conducts investigations himself. He can completely understand. And he says, sure, why don't you ask him consent? We want to make sure everything is completely tight in this case. We don't want to leave anything that's unturned. Can we please search your house since you had nothing to do with this anyway? Let's just search your house to make sure we're crossing all our T's and dotting all our I's. Did you even do that? No. He also pointed out that on the report, it said that he had found 3 pieces of taillight and he showed to the jury 4. So he had some fun with that. Also, he said, what about the eyewitness? There's an eyewitness that put the Ford Edge between 2:30 and 3:30 in the morning in front of 34 Fairview. And he said that they followed that lead, but they decided that the witness was not reliable. And he said the timing was off. He was colorblind, and he put the vehicle at different locations. He was completely just all over the place. So there was any reliable information that actually there was a Ford Edge, if that was the type of car, if it was actually between 2:30 and 3:30 in the morning, and if it was actually in front of 34 Fairview as opposed to somewhere else. So that's why they didn't get into that. That's why that eyewitness was not reliable. All right. Then we had Ryan Gallinari, who is a sergeant with the Dighton Police Department, who did a DNA swab on Proctor and Buchanan. So that's essentially all he testified to. Then we had Nicholas Bradford, his DNA analysis, and he essentially testified that there's strong support for John O'Keefe's DNA being on the taillight, and there's no support for Proctor or Buchanan, their DNA to be on that taillight. Also, he testified that here, as we know that here, from the back of the vehicle, there was certain mitochondrial testing that had to be done, and he doesn't do that type of testing. Then we had Tess Chart, another DNA analysis, and she did do mitochondrial testing on the shaft here, which is the shaft here is the opposite of the root here. So the shaft is the part away from the part of the body. And she did some testing, and that was consistent with it being John O'Keefe. And then we had Andrea Porto, who's also a DNA scientist from the Massachusetts State Police, and he tested the root end of the hair, and he said the root end of the hair that was by the taillight could not be determined, but he did determine other things like the drinking glass had DNA from John O'Keefe. The passenger side taillight also was from John O'Keefe, and the stain on the jeans and the T-shirt and the gray long sleeve shirt also was John O'Keefe. Also, he testified that cold temperatures preserve DNA. And there wasn't really too much cross-examination on these witnesses because the DNA is what the DNA says. You're not going to say, well, there's only 500 quintillion times and not, something else. So there's not much to say. But I think what could have been done, and sometimes I do this, what could have been done is you could have just gotten up and say, I just want to make clear what your testimony is. Your testimony here is that here that you tested, or that taillight that you tested, was from John O'Keefe. You're not here to testify about who planted that here on the car, right? And of course that would elicit an objection. But your point is made that, of course, they have no control about who put that stuff there, whether it actually came naturally because he was hit by a car or because it was being planted there. All right, now let's get to day 25. You've lasted this long, you get to hear about day 25. Day 25, the first thing that court starts off with is the fact that there was a juror that was dismissed. It seems for personal reasons. If anybody has any more information about that, I haven't heard anything more than just personal reasons. So one juror is dismissed, and they always have alternates for this reason. So we heard from Jessica Hyde. Okay, Jessica Hyde is a digital forensics expert, and she is a very smart woman. I think we've all were able to tell that right away. She's just talking way over everybody's heads. I mean, obviously, she is a really, really big expert in this field. She's really, really obviously a big expert. And if you're able to follow her, great. But essentially, after about an hour and a half of her testimony, what it came down to is that she was testifying about the Google searches that were done on Jennifer McCabe's phone. Okay? And there was some, as we all know, the 2:27 a.m. Haslong to Die in Cold Google search. She basically explained how all of that doesn't really mean that Jennifer McCabe actually searched, and the fact that it showed on the Celebrate report that it was deleted, that really is not true. It wasn't deleted, and it wasn't searched for either at 2:27. She explained this all in her world of digital forensics, and how this all works is beyond me. But that's essentially what her testimony came down to. Testimony came down to that, according to my expert testimony, she did not do that Google search at 2:27 in the morning, and she didn't delete it either. And whoever wrote the Celebrate report doesn't really have the same expertise as I do, and I was able to determine that, no, this was not deleted, and it was not a search that was done at 2:27 in the morning. Now, on cross-examination, how are you supposed to cross a witness like this? Okay, obviously, this witness is extremely smart, much smarter than you at the table. Okay, as smart as you think you are as a lawyer, and as well as you read up on some of the stuff that come up on your case, you read about some of the medical stuff, and you read about some of the digital stuff. Of course, you have some sort of an elementary knowledge about it, but you're not going to be anywhere near. And of course, you have your experts also, so you're not going to be anywhere near this expert. So there's a few different ways to be able to attack a witness of this type from Jessica Hyde. Okay, you're not going to get her on the way that on her expertise. You're just not. So if your expert has some points that she can't really argue on, then you can make some points like that. Another way is the fact how she got involved in this case, and how much she's getting paid by it, and who's paying her. So you could have brought out, hold on, the state was the one, and the cross-examination, I think something that made a mistake, and then he made a mistake one, was trying to say how you're not saying that she could not have done the search at 2:27 in the morning, right? Well, actually, that's exactly what she's saying. She just explained in her very experty way that Jennifer McCabe did not do that search at 2:27 in the morning. It's all a mistake. You guys just don't understand how phones work. If you understood at her level how these phones work, then you would understand that she did not do that search at 2:27 in the morning. So you don't argue with them necessarily at their final conclusions, because they're going to get you. But what you could say is the fact that she only got involved in this case after the defense had an expert who was able to show you that these searches were deleted and that these searches were done. So you could point out the fact that, I just want to make something clear. You got involved in this case because we, the defense, went and got an expert who was able to show that this search was done and this search was deleted. So let's just get this straight. After the Commonwealth understood that, there's already this Celebrate extraction, which generally that's all you need. You have the Celebrate expert that comes on and says that they did this extraction. They show what the text messages say or the Google search say, and that's it. You don't have these really experts like Jessica Hyde come in. So you only got involved because we had our expert look at this Celebrate, and we showed it to the state, and then the state had to explain to the jury. They had to scramble to try to figure out how to explain this away that will fit with their case. Right? I just want to make sure that I'm not pinning anything on you, but I'm just saying that's how you got involved in this case. Because after we showed the defense how innocent Karen Reed is, you had to come in and try to figure out how she's not innocent, right? I just want to make sure about that. Okay. So that's a way to attack your expert. At the end of the day, when they have one expert, you have another expert, so then you can just hang your hat on your expert. And then to the jury, you can say, look, They have their expert. That's fine. We have our expert. Our expert is really, really good. He knows what he's talking about, and this is what his opinion is. All right. And especially when you're the defense in a criminal case, you can say, and maybe you don't know which expert to believe. That's fine, because as far as the defense is concerned, I don't care which expert. You don't have to go with one expert over the other. If you're just not sure, if you have a reasonable doubt that maybe our expert is true, is actually saying the true information and is more reliable or whatever, it's just a reasonable doubt. So if you're not 100% sure, great, she's innocent, and then you can't come back with guilty. All right. Well, anyway, so then there was we had the accident reconstructionist, Trooper Joseph Paul. And again, this expert really is probably the strongest witness that we've seen so far for the Commonwealth. The strongest witness. Because he went through, again, it took him hours to get to the actual evidence that he's actually testifying about. Essentially what he testified was the fact that everything about this, the car's information that he was able to download, everything about it would suggest that this was a pedestrian versus motor vehicle accident. Everything suggests that. So there's no airbag deployment. That's normal. And then he also shows that this vehicle did a turnaround around 8 minutes before going into reverse and getting the car up to 24.2 miles per hour. Now, the car goes from 24.2 miles per hour to 23.6 miles per hour. Now, why would there be such a small drop like that? And the reason is that if it came into contact with a pedestrian, there's only a small amount that would go down before eventually braking. So he said that that's also very consistent with a pedestrian being hit by this car. Also, the fact that the steering wheel went from left to right and then left again. That also shows that that's consistent with the vehicle hitting a pedestrian. Also, he testified that the injuries are consistent with the pedestrian getting hit by the car going backward, and he explained how exactly that would work out. It's not a head-on hit where you would expect injuries below the neck, more of a side swipe type of hit near the taillight and flipping him around or spinning him around where he eventually lands on the curb with the back of his head and knocks his head open. So a few main points that he brought out was the fact that this evidence that we've been hearing about finally comes out, that there's data from the car that he was able to download to show that this car at this specific time, at this specific mileage, was thrown into reverse and gunned to 24.2 miles per hour, hit something, then went to 23.6 miles per hour, and then eventually stopped. So this is, if you want to believe that Karen Reed killed John O'Keefe purposely, this is your witness. This closes the case for you. It's straight out data. Now, we haven't heard yet from the defense's expert, but if this is all you have in this case, then you are very, very close. You're very much there to finding Karen Reed guilty in this case. Now, there's still some other arguments to be made. I'm not saying that. There's definitely some arguments to be made. But if you buy what this accident reconstructionist is selling, that all this data points to the fact that this car was thrown into reverse and gunned to 24.2 miles per hour, what was going on? And if everything's consistent with pedestrian strike, then it seems that that's what she was doing on purpose. So with intention. Now, whether that's enough then to kill him, okay, that's another argument. But this really is the strongest witness. And by the way, this is also why some people are asking me how this whole trial is being tried by the Commonwealth. First, we're putting on all these weeks and weeks of witnesses, of late witnesses, of all the Alberts and the McCabe's, and going through all these other, all the police officers, and finally getting to the expert witnesses. And I also said that a lot of times I like to try my cases the same way. I like when the experts go last, because the experts sometimes can do what this is. The first 3 weeks of going back and forth, getting all the petty arguments about whether you were there, what did you see, what didn't you see. Here you have an expert saying exactly what happened. And if you rest your case shortly after, the experts come and say, this is what happened, it's all science, it's clear, then case closed. So this is the strongest argument for the Karen Reed guilt so far, up until now. Up until now, we've been seeing a lot of holes and great arguments for the defense side with the other witnesses so far. we will see, and again, we haven't seen any cross-examination yet, and we haven't seen what the defense's accident reconstructionist can say. The accident reconstructionist from the defense perhaps can say that this is all junk, and none of this is true, and he did his own analysis, or she did her own analysis, and she got completely different findings. So that's possible. We have to see. But at the state where we are, at the stage where we are right now, this expert really wins it for the Commonwealth. And I don't want to say wins it, but really is a very strong witness for the Commonwealth. All right. So before that, after that, his testimony, there was some voir dire, and the jury was excused. And what happened now is that he was going to testify. This trooper, Joseph Paul, this reconstruction, was going to testify about that video at 5 o'clock in the morning of Karen Reed backing up her car, backing out of John O'Keefe's house, and coming into contact with John O'Keefe's Chevy Traverse, right? So that we've seen that video, and we also saw how Alan Jackson blew up the tire, the rear tire of John O'Keefe's car to show that the car moved, to show that there was some contact between Karen Reed's SUV, Lexus SUV, and John O'Keefe's car. We've seen that. Now, he was about to give testimony, and this is why the jury was excused. He was about to give testimony about whether that is consistent or that's a strong enough force to cause the broken taillights that we've seen in this case. And of course, we know that his expert testimony is going to be that no, just a small impact like that is not able to break the taillight in the way that we've seen in this case. That's essentially what his testimony is going to be. And this obviously is extremely damaging for the defense, for Karen Reed, because that's essentially what they're hanging their head on. They're saying that the taillight was broken from that impact. Now, of course, they can also argue, even if it was not broken, the police later broke it themselves and planted it all themselves. But it's easier to say that this is actually what happened. So the reason why the jury was excused and there was voir dire on this is because this, again, is an expert opinion that was not disclosed to the defense before. All of his other opinions about the speed of the car, going into reverse, everything that we've spoken to up until now was all disclosed. It was all in his report. This specific video of the Ring camera footage, it was never disclosed what his opinion is going to be. And therefore, like we've spoken about before, this is trial by surprise. You can't give a new opinion if you're an expert in a trial unless you've disclosed that opinion in a report or in some other way to the other side about what you're going to testify about, and that way they can get their own expert to rebut that, or they can prepare for cross-examination. So this was Alan Jackson's argument. It's a very good, strong argument. When pressed about when Mr. Lally was pressed by the judge why he didn't turn this evidence over, he didn't have such a great answer, and therefore I would, if I had to guess what would happen, I would assume that this is not going to be allowed in. Now again, anything can happen, but she said she's not going to rule on it just yet. She's not going to rule on it just yet. She's going to think about it, mull it over, and then come to decision, I guess, tomorrow, on Monday. So we'll see what she decides on Monday. But certainly, if she allows this evidence in, this is going to be one of the appealable issues if it comes back with a guilty verdict on Karen Reed about the fact that they did not get this disclosure before about this opinion that this expert is going to give about that specific Ring footage video. All right, well, that is it. Now you are all completely caught up with the Karen Reed case, getting ready for next day on Monday, and continuing with this case. Hopefully he's going to be wrapping up soon, so we're going to get hopefully to a verdict within the next few weeks. So that will be it for now. Thank you all for watching. If you haven't yet, please subscribe, like, and we will see you next time.